Dear learners, I welcome you all to this course on understanding human rights. Today we are going to discuss the major issues of violation of human rights in India and especially rights and status of women in the country. Before this, we discussed the status of minorities in India. We have identified some vulnerable groups, women, for example, minorities, for example, SC, ST, for example. These are the vulnerable groups in the country. Women are, of course, vulnerable everywhere in the world. So that is why, after discussing the status of minorities in the country, what are the challenges they are facing, what are the issues that have been highlighted by the human rights organization in the context of the protection of minorities that we have discussed. Now we are going to discuss the status and the rights of minority rights and the status of women in India. So here we go. First of all, we will try to introduce the topic and then rights and status of women in India, enactments related to the rights of women, then violations of women's rights, NCW and NCRB reports, because these are the two most authentic organizations that you will find. Then efforts to address violations of women's rights in India. As you all know that the human rights are important and necessary for all without any discrimination, but for vulnerable groups it has its importance increased manyfold. So there is no doubt in it that human rights are important for all human beings, and right from the very beginning we have been discussing that human rights are available to all the people, or the human rights are claimed by all the people, and the modern discourse of human rights or the contemporary discourse of human rights that recognizes the fact that everybody, every individual has human rights by virtue of being human. So human rights are legitimate claims of all individuals. We have been emphasizing they are inalienable, they are inherent. But at the same time, you'll find when we try to understand human rights, and especially in the context of the vulnerable groups, marginalized communities, socially excluded groups, or what we call peripheralized groups, or the non-dominant groups, then the rights become more important, and their importance, their significance increase manyfold. These are the groups that need human rights protection more as compared to non-vulnerable groups. So the society, for example, if it is divided into dominant and non-dominant, then no one can deny that the non-dominant sections of society, they need a special protection. They need a special care. And that is why, the rights of the vulnerable groups, that become important. Vulnerable groups include women, children, migrant workers, refugees, stateless person, disabled people, indigenous people, aged group, as well as people belonging to ethnic, religious, and linguistic minorities. So, these are the vulnerable groups. But at the same time, we must know that when we talk of, for example, women, they are not monolith. When we talk of minorities, they are not monolith. Even when we say majority, majority are also not monolith. So the diversity of situation, the different kind of challenges, the layers of exploitation and subjugation and marginalization that we have to understand in the context of all groups. Here we are going to identify the rights of women and what are the challenges they face in the country. Gender discrimination is one of the age-old practices everywhere. So, right from the very beginning, you will find that discrimination against women have existed in all societies. It has existed in all societies, discrimination against women. So much so, you will find that earlier the women were not considered fit for right to be given voting right, and that was not available. In most of the countries, you will find voting right was granted to women only in 20th century. And in many advanced countries, you will find that the voting right to women was given after the Second World War. So that shows, you see, that what kind of discrimination they were facing. Most of the societies have been male dominated, or you can also say male chauvinist also, many societies, or the trend of male chauvinism. So that is why they try to determine the ways of life or prescribe the ways of life for women, so that is there. And the discrimination has existed in all the societies of the world. It has been prevalent in Asia, Europe, Africa, and in almost all other societies since ages. Discrimination on the basis of gender is a disrespect to human rights and violates the norms and values of equality of rights mentioned in the Charter of the United Nations. So, the gender discrimination is an issue that we are uh, recognizing that it is violation of the spirit and the objects and the purposes of the UN Charter that that is talking about non-discrimination and equality of opportunity for all sexes. But here you will find that the violation of the rights of women or the denial of right to women, that is violation of the principle that have been enunciated in the UN Charter and its many treaties and instruments of human rights. The preamble of the UN Charter asserts its faith on fundamental human rights for men and women equally. So the preamble of the UN Charter itself is emphasizing that there should be equality and the rights should be available to all human beings or to men and women, so that there should not be gender discrimination so far as the rights are concerned. We it mentions we the people of the United Nations, that we are reading out from the Charter of the United Nations. We the people of the United Nations determined, and what we determined, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and nations large and small. What is being emphasized here? That the nations large and small. So to reaffirm faith in fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women, and nations large and small. So what is relevant for us, that it is the equal rights of men and women that is being recognized by the UN Charter in the preamble. Of course, the nations large and small, whether they have an equal right or not, that is quite debatable and a contested claim, because you will find that 5 nations are there in the UN Security Council who have privileged position, and so that is why it is not equal rights of nations large and small, because that is the inherent contradiction of the UN Charter. On the one hand, it is talking about the equal rights of nations large and small, and on the other hand, it has already created 5 privileged nations, and they have been given a special veto power. So that is a very different matter. Here we are concerned with rights of men and women, equal rights of men and women, that is being proclaimed by the UN Charter. Article 1 of the Charter proclaims that to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedom for all without distinction as to race, sex, language, or religion. You see, that is being highlighted here. That is Article 1 of the Charter, which proclaims to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and in promoting and encouraging respect for human rights and for fundamental freedom for all without distinction as to race, sex, language, or religion. This is being emphasized, that the principle of non-discrimination. In 1946, the Commission on the Status of Women was established to deal with the issues related to women's rights, but it did not have much effect on the condition of women, as women were victims of deeply ingrained patriarchy in the society, and it was a bit difficult to be removed by law. So you see that law is something, for example, legislation can be there in a country, but if the society itself is not sensitized, people at large are not sensitized to accept, then the legislation will not do many things, because the violation of the rights of women or the human rights violation have the 3 kind of dimensions, that at the individual level the human rights can be violated, then at the societal level human rights can be violated, and the human rights can be violated by the state as well. So that is why we are more concerned most of the time with the the violation of rights by the state. For example, if police torture is there or the police encounter is there, then we always talk about human rights. Or sometimes police may be justified in some cases as well, but you'll find that the human rights issue is most of the time highlighted. But what about the societal violation of human rights? Societal violation of human rights when we are talking about, uh, so for example, CAP, for example, you see the social terrorism means organizations trying to protect what is called the honor and dignity of the women or the community, and in the name of that they go for honor killing. Also they try to impose certain kind of restrictions upon the women, that they can do this and they cannot do that. So therefore the societal violation of human rights or the rights of women is quite rampant, and you will find in all the societies that certain roles are assigned to the women, and that too in a patriarchal framework. And because of that you will find the deeply ingrained patriarchy that is there. We will find, because of which only law will not solve the problem. The societal violation of human rights can be, or human rights of women can be stopped only when society at large is sensitized about the plight of women and about the legitimate claim of women to have equality in the society. That is important. Article 1 of the Convention on the Elimination of Discrimination Against Women, CEDAW, which was adopted by the United Nations General Assembly on 18th January 1979 and became effective from 3rd September 1981, defines discrimination against women as any distinction, exclusion, or restriction. You mark the words: any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. So, this is the definition of discrimination. So, for example, if women are not given the opportunity to develop, to utilize their potential and develop their, personality to the fullest extent, or any kind of, impediment is created in the way of realization of their rights to develop their potential to the fullest extent, to develop their personality to the fullest extent, that is discrimination. And from this perspective, from this broader definition, if you apply, you will find all the societies of the world, they discriminate against women. No society can successfully claim on, quite intellectually and logically respectable ground that it does not discriminate against women. However, we find that even after 32 years of adoption of CEDAW, no country across the globe has achieved total equality between sexes. So that is a dream, of course, but CEDAW should be appreciated that it has set certain target. It has also taken into account the rights of women, and it has also taken into account the challenges that the women face in the different parts of the world. And keeping in view those challenges, this particular CEDAW, which is a very, very important instrument of protection of the rights of women, has been adopted by the United Nations, for which it must be appreciated. That in the direct, so far as legislation is concerned, United Nations has done a commendable job by adopting CEDAW. But after adoption of CEDAW, you'll find that we have not been able to realize the dream of achieving equality of men and women, and that's why you'll find marginalization of women from the corridor of powers and from the bodies where the decisions are made, that are quite evident. So that is visible. After discussing these things in the international perspective, now we are coming to our main issue, and that is rights and status of women in India, because the topic is major violations of human rights in India, and the major issues of violations of human rights in India, in which we have included minorities, women, scheduled caste, scheduled tribe. So here we are going to discuss rights and status of women in India. So Article 14 of the Constitution of India guarantees equality before law to women. That is already there, that everybody is equal in the eyes of law, equal protection of law, equality before law, without any discrimination on the basis of sex and other things, that has been already highlighted. Article 15 guarantees women access to public arena as man have. So, as man has. So, all the women in our society, they have been given the right to access to public arena. So, in the public employment, for example, there should not be any discrimination on the basis of, sex as well. Other grounds are also there. For example, religion, caste, creed, sex, place of birth. So, it means that have been also assured through Article 16, for example, equality of opportunity in employment to women as men. So, whether it is public arena, public space, women have every right to share that public space with their male counterparts, and there cannot be any discrimination. That will be the violation of the Constitution, the spirit of the Constitution. On the other hand, you will find the public employment. Why? Public employment is important because you will find that the public employment is also a way to judge the status of a community, where what kind of representation of that particular segment, whether it may be women, whether it may be SC, ST, or other vulnerable groups like minorities, what is their percentage, what is their representation in the public employment. That is also a yardstick to judge whether the country has fully addressed the issues of backwardness, vulnerability, or not. So that is why Article 16 tries to provide equality of opportunity in employment to women as men have in the society. Then Article 21 provides right to life with dignity, and that is for all the citizens of India, whether they are male or female. So Article 21 is trying to provide what is called right to life with dignity. Then we have Article 39 Clause D that mandates the state to secure equal pay for equal work for women and men. That is there in the directive principle of state policy. So besides fundamental rights, we have directive principles of state policy. In the fundamental rights, which is, they are legally justiciable, legally justifiable, and you'll find that the judiciary is the custodian of the rights and liberties of the people. So that is why when we were talking about Article 14, 15, and Article 21, all, these rights, they are providing equality of opportunity and rights to women to share public spaces with other, male members of the society. All these things have been ensured. And here in directive principles of state policy also, you'll find that the issues of women have been taken up in the Constitution of India. And that's why Article 39 Clause 2 mandates the state to secure equal pay for equal work for women and men. Women have been paid less right from the very beginning in comparison to male, while they were doing the same kind of job. Sometimes they were doing better than male, but you'll find that they were paid less. So that way this issue has been taken up, and it has been included in this Article 39 Clause D. Then Article 42 secure just and humane conditions for women at work and granted maternity leave to women workers. That has been a major issue. You will find that the women are not only doing household work, unpaid work, that is, they are not paid for that, but from morning to night, you will find women have been working. Almost all the women in our country, they have been working from morning to night, taking care of household and all. At the same time, you will find rearing, bearing of children. That is also one of the responsibilities to women assigned by the society. So that is why when the women, for example, that becomes their legitimate right to have maternity leave or maternity relief. So this has been mentioned in the directive principle of state policy under Article 42. And why this is important again? Because this was also something that was denied to women for a long period of time. Now you see, if a woman is working, especially in the public sector, especially the jobs that are given by the government, then you will find that maternity leave, child care leave, for example, maternity leave, that is their right that cannot be denied to them. But of course, in the private sector, it becomes quite challenging for the women to get all this kind of relief. That is still a problem. Now, there are other issues in the country, so far as women are concerned, and that's why you'll find that the state has taken into account those issues and it has gone for necessary action. For example, we are talking about the enactments related to rights of women. So, Dowry Prohibition Act 1961, as you know, the dowry is a major problem because of which, for many families, women are projected as burden because the parents have to give dowry to women while they are marrying their daughters. That is also something that is a harsh reality of our society. That dowry is there, and the dowry often results in the lack of dowry if the parents were not in a position to give what was demanded by the grooms. So in that cases, you'll find what happens that bride burning is there, dowry deaths are there. So that is Dowry Prohibition Act 1961. Then Immoral Traffic Prevention Act 1956. Again, women are mostly, there is a kind of exploitation that is, women are forced to go for prostitution and uh, go for flesh trade and all. A lot of sex workers you will find. So, that is Immoral Traffic Prevention Act 1956. Then we have Muslim Women Protection of Rights and Divorce Act 1966. Then we have Medical Termination of Pregnancy Act 1971, because you see this issue also is very important in our country, where the pregnancy test or the sex determination test that used to lead to what is called female feticide. That right in the womb of the mother, the female baby was killed. Murder was committed by the family itself. So that's why society needs to be sensitized. It is not only the law will do everything. So the Medical Termination of Pregnancy Act 1971, then Indecent Representation of Women Prohibition Act 1986, then Commission of Sati Prevention Act 1987. You see that in our country, sati was also a practice where women were forced to burn themselves, or they were uh, motivated or indoctrinated to burn themselves with the fire of their husband. So that sati was a practice which was quite gruesome, and that's why the Commission of Sati Prevention Act 1987. And then you will find Child Marriage Restraint Act. Child marriage has also been a major problem in this country. A girl of 5 6 years, for example, if she is getting married sometime, and not only that she is getting married, but you will find at the age of 12 years, 13 years, 14 years, you know, or at the age of 14 years, if a girl is becoming pregnant, 15 years, you can understand what are the issues that she is going to face. So that is why this is again Child Marriage Restraint Act, that is also that has been adopted by the government of India, which is a welcome step. Then you will find National Commission for Women Act 1990, and then institutional mechanism was provided by the government of India, that is National Commission for Women was established to protect and preserve the rights of women. Then Protection of Women from Domestic Violence Act, that is a major issue against women, that they face domestic violence, brutality, cruelty, and that's why the Protection of Women from Domestic Violence Act 2005. Then we have the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act was passed in April 2013. This is India's first own law on the prevention of sexual harassment at the workplace. It has been a major issue, you'll find. That with the progress of the society, women started sharing spaces with the male members of the society. But you will find in many organizations or in the public arena, they were facing sexual harassment. And that's why that was becoming a major issue, that was leading to marginalization of women. They were not in a position to, assert their status in the society. So that is why this was also adopted, that is sexual harassment of women at workplace. And of course, it has addressed certain major challenges that the women are facing. Uh, this is India's first own law on the prevention of sexual harassment at the workplace. Then Vishaka guidelines need a special mention here because Vishaka guidelines to safeguard the interest of working women and protect them from sexual exploitation at workplace. Again, the issue of sexual harassment has been taken up under Vishaka guidelines. Uh, then the Criminal Law Amendment Act 2018 have also been enacted, making the punishment for offences like rape more stringent by including the death penalty for the rape of a girl below the age of 12 years. You know, on many occasions, you will find that the minor girls were raped, gruesome rape and murder. They were reported. So it was a mandate to the government to have stringent punishment for the culprits or the perpetrators when a minor girl is raped or killed. So that is why the death penalty, which of course the Supreme Court of India has already ruled that should be given in the rarest of the rare circumstances. But you'll find this is of course the rare of the rarest circumstances where a woman, or where a girl, a minor girl is raped or murdered. So that is why this is again the Criminal Law Amendment Act 2018 is important from that point of view. Then the government of India has set up a non-lapsable corpus of fund under Nirbhaya Fund framework for enhancing safety and security of women. That is, a positive kind of attitude adopted by the government to empower women. Then another is the Ministry of Women and Child Development is also implementing schemes, including the scheme of One Stop Center for violence affected women, the scheme of Women Helpline, and the scheme of Mahila Police Volunteers under the Nirbhaya Fund framework. So again, you'll find that the government of India is trying to engender the spaces, and that's why these kind of schemes have been launched by the government of India, which is of course a welcome sign. So far as the rights of women, or so far as protection of the rights of women is concerned, because women are vulnerable, that we have already seen. Uh, it is also worth mentioning that India has ratified CEDAW in 1993, and in Madhu Keshwar versus State of Bihar, the Supreme Court hold that CEDAW is an integral part of fundamental rights and the directive principle of state policy. You see, salute to Supreme Court of India. That CEDAW has CEDAW is an integral part of fundamental rights and directive principles of state policy. So you see that the scope of fundamental rights and directive principles, they become wider when we are going to apply it for protection of the rights of women. Why? Because CEDAW is also being attached. So now, in the light of this judgment, you have to read the constitutional provisions with the provisions of CEDAW as well, and you have to see the compliance of India not only in the light of the constitutional framework or the constitutional provisions, but also in the light of the articles that are there in the CEDAW or the provisions that are there in the CEDAW. The year 2001 was declared as Women's Empowerment Year, and in 10 years before that, in 1990, NCW was formed by the National Commission for Women Act. So you will find we are talking about the institutional mechanism that have been developed by the Government of India to take a special care of this vulnerable group, that is women, and that's why this NCW Act was passed and the National Commission for Women was created in the country. So, in the light of this, we are going to conclude our discussion today. We will continue this lecture on the rights and plight of women in our country and what are the protection they have and what are the protection that should be given to them, recognizing their vulnerabilities. But we are going to conclude our topic today here in this lecture. And with this, that in the next lecture, we will be taking up other dimensions of the rights of women in the country, especially the issue of violation of the rights of women in the country. But in the light of this, you can understand that the vulnerability of women in our society has been recognized, acknowledged by the Government of India, and this is the reason that certain special measures have been taken by the Government of India to protect the rights of women, to preserve their rights, and to promote their rights in the country. They have certain issues that are there may be many common issues that all Indians are facing, but it cannot be denied that women in our country had certain issues that are different from the issues that the male members of the society face. We must recognize that our society is also a male dominated society where it becomes very challenging and difficult for women to find a space to uh, to what we call assert their position. And in this kind of patriarchal and male dominated society, it becomes challenging for the women to develop her personality to the fullest extent. Thank you very much.